Welcome back, everybody. So today we'll be dealing two orders. One is order 26, that is commissions, and order 27, that is suits against government, by or against the government. Okay, so let's start with the commissions. So first heading is commissions as to examine witnesses. The first heading you can just write down commissions as to examine witnesses. Next, cases in which court may issue commission to examine witnesses. Any court may in any suit issue a commission for the examination on interrogatories. Now, commission will examine the witness on what would be the source material, what would be the questions. So the questions would be in the form of interrogatories or otherwise any person resident within the local limits of jurisdiction who is exempted under this code from attending the court or who is from sickness and infirmity unable to attend it. Now, who would be allowed for the examination by the commission? Who is exempted from this code or is from sickness or infirmity unable to attend it. Those persons would be allowed for the examination by the commission, and the examination will be done by the interrogatories. Provided that a commission for examination and interrogatories shall not be issued unless the court, for reasons to be recording, thinks it necessary to do so. So the court has to provide recorded reasons. Court has to record reasons, reasoned order, that why provided a commission for examination on interrogatory shall not be issued unless the necessary to do so. Why? What's the necessity of doing so? The court may, for the purpose of this rule, accept a certificate purporting to be signed by a registered medical practitioner. Then the court, for the purpose of this rule, accept a certificate purporting to be signed by registered medical RMP. We call it RMP, registered medical practitioner, as evidence of the sickness or infirmity of any person without calling the medical practitioner as evidence. So we don't require to call the person to the court, but his certificate would be considered. Order for commission. Any order for the issue of commission for the examination of witness may be made by the court either of its own motion. So order could be made either by the suo motu or on the application supported by the affidavit or otherwise. So on an application or motion and supported by affidavit or otherwise of any party to the suit or witness to be examined. Under Rule 3, where witness resides within the court's jurisdiction. Now, the witness is residing within the court jurisdiction. A commission for examination of a person who resides within local limits, issuing the same may be issued to any person who would be given the responsibility to go and examine that person. Any person on whom the court thinks fit to execute it. So, any person can execute the commission. No special eligibility or requirement is required. Persons for whom examination commission may issue. Earlier we read here that persons who are exempted and persons who are sick or unable to attend it. But apart from that, there are certain other persons who are allowed examination by commission. Any court may in any suit issue a commission for the examination and interrogatories or otherwise of any person. So there is any person resident beyond the local limits of jurisdiction. Any person who is about to leave such limits before the date on which is required to be examined in the court. Any person in the service of the government who cannot, in the opinion of court, attend without the detriment to the public service. So on these three grounds, we can say the commission can be issued. So person is beyond the local limits of the jurisdiction. Any person who is about to leave before the date of which is required to be examined, and the government servant, if the court is of the opinion that it would be detriment to the public service. Provided that where under Rule 19, Order 16, provided that where under Rule 19, Order 16, person cannot be ordered to attend a court in person, a commission shall be issued to examination if his evidence is considered necessary in the interest of justice. Now tell me in the comment section what is Order 16, Rule 19, and under what circumstances it is said that a person cannot be ordered to attend a court in person. Commission shall be issued for examination if his evidence is considered necessary in the interest of justice. Provided further that a commission for examination of such person and interrogatories shall not be issued unless the court, for reasons to be recorded, thinks fit necessary to do so. Such commission may be issued to any court, not being a high court. The commission can be issued to any court, but not being the high court, within the local limits of whose jurisdiction such person resides, or to any pleader or other person whom the court issuing the commission may appoint. Alright. Next, the court on issuing any commission under this rule shall direct whether commission shall be returned to itself or returned to any subordinate court. So thereby the court would mention that whether the commission would be returned to which party, to itself or to the subordinate court. Commission for examination of any person resident within the local limits of jurisdiction of the courts. Now a person is resident. Notwithstanding anything contained in this rule, any court may, in the interest of justice or for the expeditious delay of the case. Now, in the interest of justice or the expeditious disposal of case, or for any other reason, issue commission in a suit for examination on interrogatories or otherwise of any person resident within local limits of jurisdiction. The evidence or record shall be read in evidence. So 4A say that if a person is resident within local jurisdiction, can you also issue commission? Yes, you can. If it is in the interest of justice, if it is required for the expeditious disposal of suit or any other reason. Now commission or request to examine witness not within India. Now the person is not in India, what to do? So where any court to which application is made for issue of commission for examination of person residing at any place not within India is satisfied that evidence of such person is necessary, the court may issue such commission or a letter of request. So what we said to a country, foreign country, we send a letter of request, may issue a commission. We can also issue a commission, or we can send a letter of request. Court to examine witness pursuant to commission. Every court receiving a commission for the examination of any person shall examine him or cause him to be examined pursuant thereto. Witness pursuant to commission. Receiving a commission for the examination of any person shall examine and cause him to be pursuant. Return of commission with deposition of witnesses. Where a commission has been duly executed, now execution done. After execution, what happens? Now it is saying where a commission has been duly executed, it shall be returned. It shall be returned together with evidence taken under it. So whatever evidence they have acquired, that also the court from which it was issued, unless the order for issuing the commission has otherwise directed, in which case the commission shall be returned in terms of such order, and the commission and the return thereto and the evidence taken under it, subject to the provisions of Rule 8, from part of the record of the suit. So everything that has come will form the part or record of the suit. Next, when depositions may be read in evidence. When depositions may be read in evidence. Evidence taken under commission shall not be read as evidence in the suit without the consent of the party. Now it is important, read it very carefully. Whatever evidence has been taken under the commission shall not be read as evidence. So directly that won't be read as evidence unless the party has consented to it, against whom the same is offered. Unless the person who gave the evidence is beyond the jurisdiction of the court, or dead, or unable from sickness infirmity to attend in person examined, or exempted from personal appearance in court, is a person in the service of government who cannot, in the opinion of the court, attend without detriment to the public servant. The court in its discretion dispenses with the proof of any circumstances mentioned in clause A and authorizes the evidence, the person being read as evidence of the suit, notwithstanding the proof that cause for such taking evidence by commission. It just says that parties should consent to it. Okay, shall not be read as evidence in the suit without the consent of the party against whom the same is offered. Alright. That is, unless this part shall not be read as evidence in the suit without the consent of the party against whom the same is offered. Person who gave the evidence, or notwithstanding proof or taking such commission, has ceased at the time of reading the same. We'll read it. Okay, this is like a check, you can say. They just reach the subject of the provisions of Rule 8. This is the subject of the provisions. We'll see commissions. In the later sessions, I will tell you about the commissions Rule 8. Or just after a while, I'll when let's just complete this order and then I will let you know about this. Commissions for local investigations. Now for A part was commissions as to the examination of the witnesses. Now B part talks about commissions for local investigations. So you can also do the this question is also asked, under what circumstances commissions can be issued. There is a separate section for it, a line of sections indeed. So in the comment section, please mention the section number where the commissions had been ordered. So you can do for the examination witness, you can do for the local investigation. Now what are the rules for that? Commissions to make local investigations. In any suit in which the court deems the local investigation to be requisite or proper for purpose of elucidating in matter of dispute, or of ascertaining market value of the property, or the amount of any mean profit or damages or annual net profits, the court may issue a commission to such person as it thinks fit. So what local investigations? The Act has provided that local investigation may be requisite, it is proper for the purpose of elucidating any matter in dispute, or market value determine, or determine mean profit, damage to the annual net profits. All these are covered in the local investigation, and report therein to the court, provided that where the state government has made rules as to the persons to whom such commission shall be issued, the court shall be bound by such rules. So who would make the commission, who would make the rules as to the local investigations? The state government will make the rules as to the local investigation. Now what would be the procedure of commissioner? What would be the procedure? The commissioner, after such local inspection as he deems necessary, and after reducing to writing the evidence taken by him, shall return such evidence together with his report in writing signed by him to the court. Now what he would do? Evidence together with his report reduce and send into the court. Report and dispositions to be evidence in suit. Commissioner may be examined in person. So now commissioner can also be examined in person. The report of the commissioner and the evidence taken by him, but not the evidence without the report. Not the evidence without the report. So report is necessary, shall be evidence in the suit, shall form part of the record, but the court or with the permission of court, any of the parties to the suit may examine the commissioner. So who would examine? Court would not examine. Any of the party with the permission of the court, any of the parties to the suit may examine commissioner personally on open court, touching any of the matters referred to him or mentioned in his report or as part of his report as to the manner in which he has made the investigation, where the court is for any reason dissatisfied with the proceedings of the commissioner. So where the court is for any reason dissatisfied with the proceeding of the commissioner, here dissatisfaction of court. Court is not satisfied, it may or direct further inquiry. So the court can also issue order further inquiry to be made as it shall think fit. Now C part is there. Commissions can also be made for scientific investigation, for performance of ministerial act, for sale of movable property, not immovable, sale of movable property. Okay, this is the C part. So commission for scientific investigation 10A, where any question arising in the suit involves any scientific investigation which cannot in the opinion of court be conveniently conducted before the court may, if it thinks necessary or expedient in the interest of justice to do, issue a commission to such person as it thinks fit, directing him to inquire into such question and report thereon to the court. The provisions of Rule 10 of the order shall, as far as may be applied in relation to the commissioner, may apply to the commissioner appointed under Rule 9. So it says that whatever local investigation or same process will be there. 10B, ministerial act, just remember like this, and 10C is for the sale of movable property. Then moving forward, court to examine accountants. Court to examine accounts. So we have Rule 11, commission to examine or adjust accounts. In any suit in which the examination adjustments is necessary, just heading is important, you should just know. Adjust accounts. 12, to give commissioner necessary instructions the court will give and proceedings to report to be evidence. Court may also write further inquiry if it is dissatisfied. Now we have D. D is to make partitions. Commission can also be ordered for making partitions. Commission to make partition of immovable property. When a preliminary decree for partition has been passed, the court may in case not provided by section 4, not provided, issue a commission to such person as the things fit to make the partition or separation according to the rights as declared in such union. And the 14 is a procedure. The commissioner shall, after such inquiry as may be necessary, divide the property into as many shares as may be directed by the order, as it is. And then we have general, that is 15, expenses of commission to be paid into court before issuing any commission. Under this order, the court may order such sum as it thinks is reasonable to the examined for the commission in the time of paid into court by the party to whose instance or for whose benefit the commission is issued. The party who is issuing the commission will pay the cost in the court. Powers is rule 16. 15 is the cost and 16 is the powers of the commissioner. Any commissioner appointed under this order, unless otherwise directed, order the appointment, examine the parties by themselves, any witnesses, any of them produce, the person thinks proper to call, give evidence, call for, examine documents, other things relevant to the subject of inquiry, at reasonable time enter into upon land or building mentioned in the order. So these are the powers. So questions objected to before the commissioner, this is also important. So rule 16A, order 30 or 31, you tell me. Order, it's not 30, it's not 31, it's order 26. Alright. Questions to be objected, this is important. So which objections raised before the commissioner? When any question put to witness is objected to the party or is proceeding before a commissioner appointed in this room, the commissioner shall take down the question, the answer, the objections and the name of party, and as the case may be, the pleaders objecting, provided that commissioner shall not take the answer to the question which is objected to on the ground of privilege, but may continue with the examination of witness and leaving the party to get the question of privilege decided by the court. Leaving the party to get the question of privilege decided by the court. The commission shall not take the answer to the question which is objected on the ground, but may continue the examination of witnesses. And when the court decides that there is no question of privilege, the witness may be recalled by the commissioner, examined by him, and the witness may be examined by the court with regard to the question which was objected on the ground of privilege. Alright, no answer taken down on the subpoena shall be read as evidence in the suit except by the order of the court. The order of the court is necessary. Attendance and examination of witnesses before commissioner. Attendance and examination of witnesses before commissioner. So the provisions, it is summoning attendance, endowment, remuneration, penalty shall apply to the person so required has been, provided the commissioner is not, provided when the commissioner is not the judge of civil court, he shall not be competent to impose penalties, but such may be in the application of such commission by the court. Next we have commissioner may apply not within local limits to issue the any procedure when necessary. Parties to appear before the commissioner, application to execute decree, court to fixed time return. Court may issue satisfied so fixed. Okay, there is no time period given. Commissions issued by instance of foreign tribunals. So this is E part, E heading, foreign tribunals instance. Cases in high court may issue commissions to examine witness if a high court is satisfied. Here foreign tribunals, high court. If high court is satisfied that a foreign court is satisfied in a foreign country wishes to obtain evidence of a witness in proceeding before it, that the proceeding is of a civil nature and the witness is residing within the local limits of high court's appellate jurisdiction, it may, subject to the provisions of Rule 20, issue a commission for examination of such witness. Evidence may be given by the matter specified by a certificate signed by the consular office of the foreign country of the highest rank in India and transmitted to the high court through the central government. By letter of request issued by the foreign country, court transmitted to the high court through the central government. By letter of request by the forward procedure required by the party to the proceeding. By the central government also it can be done and by the party to the proceeding. 20 is a check. So application, the high court may issue commission under rule 9 upon application by the party to the proceeding before the foreign court or on application by the law officer of the state government acting under the instructions of the state government. Alright. Subject to the provisions. Alright. So Upon an application, High Court may issue commission. No? The state government lawyer has to present it in a party. Letter of request, foreign country transmitted to High Court through the central government. To whom commission may be issued? A commission under writing may be issued to any court within the local jurisdiction. Issue, execution and return of commission, land transmission evidence to be foreign court. This is not necessary. So we are done with the order 26, and I hope you have understood very clearly. I will prepare a separate video in which we will deal topic wise, and in topic wise we would be dealing sections and orders as well. All right, so see you in the next class.